Secretary,
Yes, Your Honor.
your advocate was updating the court on your report. Can I hear it from your own mouth? What have you put in that report?
Okay. Thank you. And my apologies for running late. Can everyone hear me?
Proceed.
Right. I was updating the creditors and the court that there was a principle in the restructuring plan that Cytonn Investment Management had put in and had concerns around the same. And
Concerns about? You are muted. You are muted. You are muted. You are muted. Yes.
Okay. I had updated the creditors and
Yes.
the court on the restructuring plan that Cytonn had forwarded to myself as the administrator and to the general body of creditors, and set aside 7 concerns that that I had around the restructuring plan that they had circulated around. I also then addressed issues to do with the whether or not Cytonn had claimed that it was a creditor, and I clarified that at the time I had put this report.
May I ask Mr. Curator to disconnect from his phone? That's what the interference is. I think he's still logged in on his phone. Or he's muted again.
Curator, you are muted. I can't hear you. Curator, you are muted. Curator, you are muted. Curator, I can't hear you.
Can you hear me?
Yes, I can hear you now.
Okay, sorry. I have logged in from my colleague's. I've logged in from my colleague's account. I hope that's acceptable.
Yes.
Okay, good. So I had, as I had mentioned, that I had set out my concerns around the restructuring plan that Cytonn Investment Management had put out, and had clarified that as to whether or not Cytonn Investment Management was a creditor as of the time I had written this update out, and I clarified that the meetings that Cytonn were holding with a section of the creditors were not creditor meetings under the Insolvency Act 2015 in my interpretation, as the Act was very clear as to how creditor meetings are held and how decisions are made on the same. I also then clarified on the funding of the administration and the need to hold the second credit, and the reason why we had been unable to hold the second creditor meeting as per your court order dated March 10th, 2022, that we did not have the funding at that point in time to hold it, but we were able to get the funding for the meeting, and that is the second creditors meeting that I called for last week, which was to have the creditors vote on the administrator's statement of proposal that I had prepared and circulated to all the creditors on 28 February 2022, with my view as the administrator on what is the way forward.
The court wants to know, when the order for administration was made, you disclosed to the court that either you or the directors that the assets of the company were in the region of 10 billion. Have you disclosed the amount of assets that has come under your watch?
Okay. So if I may clarify for that, on the administrator statement of proposal, I clarified on the two entities. So if I may confirm that the two entities for Cytonn High Yield Solutions, the statement of affairs had the assets at the assets principally being loan notes at about 10.1 billion, and the creditor, and for Cytonn real estate project notes, which we commonly refer to as CPN, as at about the 4 billion mark by way of loan notes. And this was disclosed to the creditors in the administrator's statement of proposal under section 6 of that report.
You know, are you answering my question? Have you taken possession of and identified those assets?
Your Lordship,
Remember,
the
you are here
assets-
asking me to extend your terms. I want to know whether in that report you have disclosed anywhere that, yes, after taking over administration, this is what I did. I have been able to identify assets worth 10 billion or 14 billion out of the debts of 11 point something billion, if I can remember very well, when you came to court. Have you disclosed
Yes.
that?
Yes, I have called in the assets for Cytonn High Yield Solutions and Cytonn Project Notes. Your Lordship,
Mr. Amoko.
are loan notes.
I am
loan notes, and
I'm
I've called
on,
all of them in.
Kerito, wait, listen to your advocate. I am on 063, 2021.
Yes, you're on 063.
Which company is that? Which company
That
is
is
that?
Cytonn High Yield Solutions, CHYS.
Cytonn High Yield Solutions. Tell me,
Yes.
Mr. Kereto, at what section of your report you have disclosed this Cytonn High Yield? At section? Kereto?
Yes, I can hear you. Please repeat the question. What have I disclosed?
Have you disclosed in your report that after taking administration, I have identified and taken possession so much assets of this company known as Cytonn High Yield, blah, 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 so that I can know when I see your proposals, I know where we are headed?
Yes, I have done the same in Section 8. Your Lordship, the assets of Cytonn High Yield Solutions are actually only loan notes. They're not the physical assets. So I have called in all the loan
in
notes
Section 8
of the Administrator's Statement of Proposal.
Of my proposal, the assets of the company as being they are being what? They are what? The proposals are, I mean, the assets are?
The assets that Section 8 is the Administrator's Summary of Work Done on the Administrator's Statement of Proposal.
Mm-hmm.
Yes.
So you disclosed what assets? Valued at what?
Okay, so I have disclosed the assets at in the summary of work done. I have disclosed that I've called in the loan notes, but I have then if I may take you back, my lord, to
Are you understanding me, Mr. Kereto?
Yes. In the entire Section 6 of the report, I have gone through every loan note and given its value and the status of each of the projects. And there are two schematic.
Mm-hmm.
Yes.
The loan notes are valued at how much?
The loan notes are valued at 10 billion, sorry, 11 billion 715 615 11 billion 715 million 615 785 million shillings. That's a combination of cash and cash equivalents, trade and other receivables, and the loan notes. So that comes to 11.7 odd billion shillings against creditor claims that we were assuming of at that point in time of 12.4 odd billion shillings.
Are these assets under your control and management?
Yes, I have called in every single loan note. What I do need to disclose to the court is that the principal partner then informed me that 6 days prior to the administration, every single SPV that was lent the money was given a moratorium prior to the appointment of the administrator.
Every single what?
special purpose vehicle, every single special purpose vehicle, my lord,
given a moratorium of what?
Was given a moratorium by the principal partner a week prior to the appointment of the commencement of the administration. So each of these
for how long?
They have not disclosed how long they gave the moratorium for. That is information that I've been seeing.
Period not disclosed.
Yes.
And you think that was not important for you to be disclosed, and if and it was not disclosed, you come back to court to give the necessary orders, Mr. Kereto?
I have been engaging with them to provide this information.
You are engaging with them, yet I gave you permission to run this. Do you know that there are creditors who are lining up and they want to know the fate of their investments? Why would you go to bed with the people who have brought us where we are? Mr. Kereto?
Yes, your Lord.
Have the application for extension been responded to the other parties by the other parties?
The only person who has responded and served us is Mr. Kavita on behalf of the creditors committee with question if I'm not aware of any other response.
Let the parties file and exchange submissions within 3 days. Lauren? Ruling on where is this 16th? Ruling on 16th of December 2022. Very well. Sophie, are you there now?
Yes, Judge, I am here. I'm sorry to have joined late.
Call out
the matter, my lord.
Yes, matter number
Your
2.
Lordship, Your Lordship, there is also another application that was coming for mention today.
Which one?
That's the application, our application that is dated the 24th.
It is for what?
The 24th November 2022. This application, we had filed it a week ago. It's the application that we were seeking the court to stay the creditors meeting that had been called by the administrator during this period of interim extension. So we've not received any response. And in that case, we would request that the court to allow the orders as they are in the application. Because the court it allowed prayer number 1 that stayed the meeting in the interim. And then prayer number 2 was to stay until now a substantial ruling has been made. So in the circumstance, I will request the court, I will be asking the court to make to allow that prayer.
My lord, the priority at the particular moment is, of course, whether or not the period of administration is going to be extended. Until and when that is done, there is little we can do. I can undertake that we will
Can we move on to the E64 of 2021?
Yes, insolvency petition number E064 of 2021, Cytonn Real Estate Projects versus Office of the Official Receiver.
My lord, I continue to appear for the administrator here, who is also on call.
Your Lordship, Mansia, I continue to appear for the creditors committee.
Your Lordship, in the matter
to appear
for
Cytonn Investments Management. Mweke for Cytonn Investments.
You are who?
Mweke.
Mr. Mweke for Cytonn Management PLC. Yes.
Bobo Tieno. I appear for a creditor by the name Lenda Nyam Mugoi.
Yes.
Your Lordship, Miss Mogo for the official receiver.
Yes.
Your Lordship,
Your Lordship,
I have a creditor, Mr. Fresh Kerari.
Kerari.
Your Lordship, Achola, for Ochieng Opio and John Madeka, creditors.
Mr. Who?
Achola, Your Lordship, Achola. For Ochieng Opio and John Madeka, creditors.
Yes. Anybody else? Yes, Mr. Kereto, are you there?
Yes, Your Lordship, I'm here.
In this one, what have you disclosed?
Similar to CHYS update done on the 23rd. I have the administrator's statement of proposal issued on 28th February 2022. I have disclosed to the creditors that the first issue on the update on the court matters that are ongoing were been taken to court by the Committee of Inspection. I had also given my comments once again on the restructuring proposal that Cytonn Investment Management circulated to myself and all the creditors, and set aside the concerns that I had as the administrator. I've also clarified an issue to do with the funding of the administration at that point in time, and I was trying to raise the funding to be able to hold the second creditors meeting, and then that was that I responded to the creditors of CPN, as well as the detailed administrator's statement of proposal that I issued on 28th February.
What and how much? What and how much assets have you disclosed that you have taken control?
Under the administrator's statement of proposal, one moment. For CPN, we have disclosed the asset position as 3.292 billion position, and the liability position at 3.68.
Mr. Gereto,
yes,
that is hot air. Disclosure. I want you to tell me I have disclosed the assets are one telephone asset, two properties, so much bank accounts, all valued at 3.2 billion, and they are under my control and direction. That is what I want to hear.
Yes, okay. In the administrator's statement of proposal on section 6, the statement of affairs, I have disclosed the entire listing of assets and set aside a Venn diagram that put us that listed every single asset on page 31 of the said report. The assets are valued at 2.8 billion by way of loan notes.
Answer the question. Are all these assets under your control and management and direction?
Yes, I have called in all the loan notes. The assets are loan notes, and I have called in every single loan note.
All this, you know, you are going on record. All these assets are under my control and direction. let the administrator file in court by close of business of 13th of December 2022, the full details and statement on oath, the assets that he has taken control over and
Hello,
for
Mr.
which
Yes.
he will be answerable for
Yes, but,
in respect of this post and IP number 0E064 of 2021. Ruling on ruling on 16th. Is it 16th?
Yes.
16th, right?
16th,
16th,
Judge.
2022. You understood that direction, Mr. Kereto? Mr. Kereto?
Seems frozen.
He's frozen. Mr. Moko, I think you understand
I've understood the directions.
direction.
And
The
maybe also
direction-
file some short submissions.
Oh, in the meantime, parties to exchange submissions within 3 days. Mr. Moko, you have understood what I've said, what the
I've
directions
understood
are.
what you said, and we'll do
A
it in both.
statement on oath detailing all the assets that are under his control and for which he will be called upon to account.
Yes, we'll do it in both matters.
Very well.
We're much obliged, my lord, and we are grateful you gave us time today.
Very well. That's all, Sophie?
Yes, Judge, that is all we had today.